Well, thank you so much, Stephanie, for being on the show today.
Oh, thank you for having me here, Rob.
Absolutely. Well, today we're going to focus on some of the pitfalls that donors can fall into if they're not aware of the guidelines and rules around these issues that we're going to talk about. And for my listeners, this is a very specific conversation. And as I was talking to Stephanie before the show, I mentioned her that this is a very unique kind of set of specific rules and guidelines around the issue of self-dealing. However, as nonprofit leaders and development, directors and fundraisers lean more on family foundations or just foundations in general, these are really, really important rules and guidelines that people need to be aware of, particularly if you support different nonprofits or, of course, if you're a fundraiser. So with that in mind, let's talk about self-dealing. Stephanie, let's start by giving a quick overview. What is self-dealing and why can it be a problem?
Yeah, sure, Rob. So self-dealing in the broad sense is when a fiduciary take advantage of their position in a transaction, acting their own interests rather than the interests of the organization that entrusted them with those fiduciary duties. So self-dealing can happen in the corporate world, in the professional service environment, and of course in nonprofits. What I'm covering here today is in the private foundation setting in general. There are a set of Internal Revenue Code, Section 4941 specifically, that defines acts of self-dealings. They include a wide range of financial transactions between a private foundation and disqualified persons. Why can it be a problem, you asked? Well, like many tax regulations, these rules can be confusing and sometimes counterintuitive. So when a private foundation and a disqualified person enter into a self-dealing transaction, many times unknowingly, they subject themselves to penalties in the form of excise tax.
That's so interesting. Okay. So again, I always strive to be as practical as possible for my listeners. I understand there's 7 types of transactions that the IRS considers self-dealing. Let's go through those real quick. What are those top 7?
Yeah, sure. But before I get into the types of transactions, let me explain the term
Yeah, absolutely. You got it.
disqualified persons. So there are several different categories of disqualified persons. One is a foundation manager that
Yeah.
includes officers, directors, and trustees of a foundation. Second one is substantial contributors to a foundation. Third, individuals with greater than 20% ownership interest in a corporation, partnership, or trust that itself is a substantial contributor to a foundation.
Okay.
Fourth, family members
Okay.
to all of the above. So that includes parents, grandparents, children, grandchildren, and spouse.
Okay.
And last but not the least, corporations, partnerships, trusts, estates, in which a disqualified person has greater than 35% ownership interest. So as you
Got it.
can see, it's a very broad
That is a broad list.
base that
Yeah.
you're working with.
Okay.
Yeah.
Again, I'm glad we're
So
going through.
now,
Okay. Now, how about the
yes,
7? Yeah. Then the 7 types of transactions.
exactly. So going back to the transaction, the 7 types, first one is sale, exchange, or leasing of a property between a foundation and disqualified person.
Got it.
Second one is leases in general.
Okay.
Third, lending money or other extensions of credit between a foundation and disqualified person. Fourth, providing goods, services, or facilities back and forth again. And fifth, a foundation paying compensation or reimbursing expenses to a disqualified person.
Yeah.
Six, a foundation transferring its income or assets to or for the use or benefit of a disqualified person.
Got it.
And lastly, certain agreements to make payments to government officials. So these are the 7 types. As you can see, these categories start off really broad.
Right.
Then the IRS actually walks back by listing out exceptions within each categories.
Okay.
So for example, we talked about lease earlier, right? However, an exception within lease is a disqualified person can lease property to a foundation
Okay.
if the lease arrangement is rent-free.
Hmm.
We talked about lending money and extension of credit. So an exception is a disqualified person can lend money to a foundation if it's interest-free. Another example, a disqualified person can be compensated for the performance of personal services when those services are reasonable and necessary for the foundation to carry out its tax-exempt purpose.
Okay.
So as you can imagine, trying to navigate between the rules and the exceptions to understand what's acceptable, what's not, it becomes confusing.
Right. Okay. Interesting. Okay. Now, I would guess when donors run afoul of these self-dealing rules, they're not often done, maybe even most often not done deliberately or maliciously. However, they probably just ran across those. They didn't even know about these guidelines or rules. Yet the penalties the IRS can impose on somebody who does cross these guidelines and rules can be pretty strict. So can you talk about the consequences of not getting this right if you're a foundation?
Yeah, absolutely. So you're 100% right. I've seen this over my years practicing. People fall into those traps without realizing, the rules were there in the first place sometimes. So the common pitfalls I've seen over the years, I can give you some examples. One is tickets and tables for fundraising events. As you know, as a board member to a private foundation, often they get invited to galas and fundraising functions put on by the public charities that the foundation support. And the board members, have a duty representing the private foundation to attend those events. So it's perfectly okay for them to attend those events using the tickets and tables paid for by private foundations. However, if their spouse or children who have no business in representing the foundation want to attend the event, the tickets has to be paid for by those individuals, not by the foundation. Another example I've seen from time to time is when individuals make personal pledges to make donations supporting public charities. You can turn around and ask your family foundation to fulfill those pledges on your behalf because you, as an individual, really need to make whole of the promises you made to public charities. Another example I've seen from time to time is board members or executives of private foundations incur expenses, right? Of course, if the expenses are for the business of the foundation that further the mission of the foundation, and that's reasonable and not excessive, perfectly fine. However, if somebody pull out the wrong credit card for once and charge a personal expense, that becomes an issue. It's actually self-dealing. What else? Well, for example, compensation is another hot topic. You're allowed, as executives and board members, you're allowed to be paid for your personal services provided to the foundation. Again, as long as they are reasonable and necessary to further the mission of the private foundation.
Got it.
Now, so again, actually, let's cut here, I think.
No worries. So editors, kind of getting to retake.
Yeah. Okay, so you asked what are the consequences. So private foundations must formally attest to whether there were any self-dealing transactions during the year when they filed the annual tax return, Form 990. So there's a specific part in the tax return where there are a series of questions looking for yes or no answers. Depending on the answers, if any self-dealing transaction is identified, then you move on to another form, Form 4720, where you first report the self-dealing act, and secondly, calculate the excise tax, which, like I mentioned, is the penalty that you pay for taking on this self-dealing act. And the excise tax is 10% of the amount involved in the act of self-dealing, and that's being imposed on the disqualified person who is involved, not the foundation, but the person who's involved. Then if the act is not corrected on a timely manner, the same 10% tax is levied upon in the next year and the year after until this act is properly unwound and both parties being put back in the original position. So as you can see, it can add up pretty
Really
quickly.
quickly. Right.
Yeah.
Interesting. Okay. So in so many of these cases, foundations can implement internal processes as well as work with an auditor, I'm assuming, to avoid really the most common self-dealing pitfalls. What are some of those key internal processes that you would recommend foundations to implement? And then if a nonprofit listener is hearing this and they're a development director or an executive director of their nonprofit, and they can kind of coach the foundations that support their organizations, again, what are some of those key internal processes that you would recommend they implement?
Yeah, I'd say first off, you want to have a conflict of interest policy in place and have your board members and executives review the policy and disclose their involvement and their immediate family members' involvement in businesses and charities on an annual basis. So this would give the foundation an understanding of the pool of the disqualified persons that they need to be aware of. So that's the first step. Secondly, it's important for the decision makers in the foundation to have a general understanding of the topic. So I'd recommend the foundation provide regular trainings to board members and executives on the topic of self-dealings. We don't need to know all the nuances, but having a baseline understanding and awareness of the issue would help those people in the position of decision making to flag any arrangement that could potentially cause problem, right? So that gives the foundation a chance to pause and consult with their CPAs or attorneys before the transaction goes on and takes place. Like I mentioned, once it happens, it's costly to unwind, and also, the reporting and the tax burden is tremendous.
Interesting. Okay.
Yeah,
Good.
if I
Go ahead.
then a couple of other specific policies that I'd recommend. One is to have travel and expense reimbursement policy in place, so that when employees or board members, they have rules and guidance to follow, so that they would only charge or requesting reimbursements for expenses that are reasonable and necessary to carry out the mission of the foundation. Another topic I mentioned was the compensation. So when it comes to compensation for personal expenses, whether it being salaries to officers or fees paid to the directors, it's important that the foundation carefully document those individuals' qualifications, their duties, and their key accomplishments. So it would also be helpful to have compensation studies done periodically to ensure that the package as a whole is commensurate with the individual's qualifications and responsibilities.
Right. Okay. Well, that makes sense. Okay. Good. No, very helpful. Okay, good. Well, so you say a few of my listeners lead foundations and they're listening to this podcast and think, okay, perhaps they've unknowingly been self-dealing and they didn't realize it, but then as they're listening to you, they're like, well, maybe we have. How can they course correct if that is the case?
Yeah, I'd say seek advice from your CPA or attorney if you have any concern. If what I talked about kind of triggered a red flag, talk through the situation with your CPA and your attorney to figure out whether it is in fact self-dealing. Now, if it is, you need to unwind the transaction to the extent possible. Then also you need to report it on the tax return, the Form 990, the Form 4720 we talked about. Then along with the forms, the individuals who were involved in the act of self-dealing need to make the payment for excise tax owed. So that's how you course correct and put the matter behind you.
Good to know.
I also want to add that it's important to work with the right CPA and attorney. So as CPAs, we have different areas of focus, just like doctors, right? You don't go to a neurosurgeon when you have a heart condition. So the same goes for the CPAs and same goes for the attorneys. You want to work with those who have expertise in tax-exempt organizations, who are familiar with the rules and the nuances specific to tax-exempt organizations.
No, very helpful. That's great. Okay. Now, when it comes to just people wanting to know a little bit more about this, obviously you offer a lot of services. What would you recommend? Like, what are the next few steps if an organization or an executive director is listening and they're like, yes, we need some help. You've already given us some guidelines of, get an auditor, work with a good CPA. Anything else about what you'd recommend them to look for in terms of resources, and then what you could offer even from your company?
Yeah, sure. So for the specifics on the self-dealing rules, I think IRS website is the the official place to get the right information.
Excellent.
IRS.gov, upper right corner of the front page, there's a charities and nonprofits section. It should take you to the tax information, tools, and resources for charities and other tax-exempt organizations that are relevant to you. There are peer networking groups and philanthropic service advisors in your area. Go seek help there. Then last but not the least, we're here. Contact us at ghjadvisors.com. Find us on LinkedIn.
That's great. Well, Stephanie, thanks so much for reaching out and wanting to share some of this, because I think it's very helpful. It's one of those things that, as I mentioned to you, we've never had anybody like you on the show to talk about these things, but it is a real issue, and foundations that are so vital to the fundraising efforts of nonprofits. You want to make sure they're doing the right thing. The nonprofits can coach them in that same way. So thanks again for sharing your insights and being on the show today.
Yeah, my pleasure. And again, thanks for having me, Rob.
Absolutely. You bet.